All right, so we're back with the Honorable Judge Thomas Trent Lewis out of Department 79, LASC.
Judge Lewis, you practiced family law for 28 years, and then about 4.5 years ago put on the robe and took the bench. There must have been some surprises in store for you. What was the biggest surprise, the biggest thing that you learned when you stepped over that line from arguing cases to having to decide them?
I would say probably learning to decide cases and not argue cases. One of the biggest challenges for, I think, every family law judge or any judge is to require that the parties develop the facts. There's an interesting tension that is developing within the canons of judicial ethics as it relates to self-represented litigants. That we have some case law that has its genesis in the DV, domestic violence arena, that talks about the importance of the court developing the facts. With the self-represented parties, of course, they frequently don't know how to make a presentation before the court. We have a large population of self-represented litigants, and so where are you the judge, and where are you are you stepping over into the concept of becoming an advocate for one of the parties? And that's a difficult balance to be sure that you protect. If your focus is on, I want to make the best decision possible, then you aren't in an advocacy position. The one thing people have said to me, well, what's it like to be a judge now? I say, well, I'm in court a lot more, but I don't have to win. And so my job, the best part about my job is I really am there every day, hoping and striving to just do what is the right thing. So that's different than advocacy. So, and both of you have been in my court, I'll ask a lot of questions. And so I think being careful that you're really searching to understand the information and the facts so that you can make a good decision, and not becoming an advocate or looking for confirmatory information that will only confirm that which your intuition tells you. Let the facts develop, and if the parties aren't able to develop the facts, particularly if they're self-represented, then make sure that the facts are getting developed. Of course, the one thing that most lawyers hate is when a judge asks a question that their opponent hasn't thought about, and it then looks as though the judge is educating the opponent. I'm more willing to step out and ask questions in the area related to decisions about children, less willing to do so in areas that just simply involve finances, where both parties are represented, because it's not my role to jump in and look like I'm advocating for one side or the other. And of course, lastly, if it involves a proceeding that involves contempt of court, then the obligation of the person that's bringing the contempt of court proceeding is to prove their case beyond a reasonable doubt, and the judge has to, and I do, even for the self-represented, just stay out. And if they don't develop their facts, then there's going to be an acquittal. So it's a common problem, I think.
Thank you, and we're with the Honorable Thomas Trent Lewis, and that will do it for this edition of Ron and Robert on Divorce. We thank you, Judge Lewis. We will be back with more from Judge Lewis, and I'd like to try to get into maybe a little bit of Elkins, and let's talk about some of the issues that we know are kind of coming up with regard to the economy and fiduciary duty. I think those are all real issues out there.
Very important questions that need to be decided and talked about.
So we'll talk to you more next time with Judge Lewis right here on Ron and Robert on Divorce. We'll see you next time. Thank you for listening to Ron and Robert on Divorce with California attorneys Ronald Saponchik and Robert Borski, partners in the Law Collaborative Los Angeles. Join us again next week for more California family law with unique and insightful discussion and interviews on all aspects of California family law. With offices in Woodland Hills and Beverly Hills, California, the Law Collaborative Los Angeles, experts in collaborative law and mediation, excellence in litigation.